Welcome to the Herrington Carmichael Employment Law Monthly Update for October 2015. My name is Alistair MacArthur. I'm the Head of the Employment Department with Herrington Carmichael. We are presenting our Employment Law Monthly Update in a different format. We are video blogging, so we hope you enjoy this, and it's intended to be a medium for you to understand the latest developments in employment law in the last month. So I'm going to kick off with the changes which took place at the beginning of October with the national minimum wage. This is where the adult rate for the national minimum wage increased from £6.50 to £6.70 per hour. There were different rates also changing for younger employees and apprentices. You may, over the last weekend, have seen the government's announcement in relation to the extension of shared parental leave to grandparents. Currently, mothers and fathers or adopters can share parental leave between them, and there is the intention to extend this to enable grandparents to also share the leave. There'll be more information on this to come, and we'll be providing that to you either through our updates and our articles. You may also this month have seen the announcements in relation to modern slavery statements and the requirements for employers with turnover of more than £36 million to place a statement either on their website or in writing about their steps or steps they haven't taken in relation to modern slavery. What an employer has to do is either publish a statement setting out the steps they've taken through their business and their supply chain to avoid human trafficking, or to provide a statement they've not taken steps. This is going to force employers to look at what steps they take to avoid slavery and trafficking and make sure that they are doing nothing which would be treated as being illegal or reprehensible in society. Moving finally to the two cases of interest this month. Firstly, the case of EAD Solicitors LLP and Abrams. This involved a situation where Mr. Abrams, who was a member of EAD Solicitors LLP, deciding to set up a corporate entity and to treat that corporate entity as being the LLP member in his place. He was forced to retire and argued that that was discrimination on grounds of his age. Unfortunately, he had to test this in the tribunal and the Employment Appeals Tribunal because EAD Solicitors tried to argue that as the corporate entity was the LLP member, he could not enforce. However, the Employment Appeals Tribunal confirmed the tribunal's position that even though the company was the LLP member, Mr. Abrams and the company were entitled to pursue age discrimination claims. Lastly, we've had a continuation of the caste discrimination claim in the name of Turkey and Chandok. That's a case whereby the individual claims that they've been treated less favourably on grounds of their caste. This case is going back to the Employment Tribunal in the early November for full determination. However, we've had confirmation of the award in relation to wages claims of £183,773.53. This is a good reminder for employers that not only must they not treat employees less favourably on grounds of race, but equally not on grounds of caste. Coming to the end of our update now, I'd like to remind you that this update is no substitute for proper employment law advice, and if we at Herrington Carmichael can be any further assistance to you, please do not hesitate to contact us on the relevant numbers. Thank you, and until next time, goodbye.